So tell me, when you say instead of helping him, you did what?
I ended his life.
A shocking update in the case of the former college cheerleader and beauty queen charged with manslaughter in connection to the death of her newborn son. Lakeen Snelling was accused of giving birth in her college apartment and then, after the boy died, hiding his body in a trash bag and leaving.
How did you end his life, then?
I deprived him of oxygen.
Okay, all right.
Today, in her own words, for the first time, we hear a shocking and emotional admission in court.
I deprived him of oxygen. 5 words, spoken in open court, that ended every legal ambiguity in this case. The judge asked a direct question. The defendant gave a direct answer. No filtering, no deflection. Just an admission that transformed a routine hearing into a permanent record.
We were not expecting this today. Today was set to be a routine status hearing in the case of Lakeen Snelling in Kentucky, but then came this.
Tell me what you did.
I was under a lot of emotional distress, and my baby came unexpectedly. And instead of helping him, I ended his life. And afterwards, I cleaned up and didn't tell him.
Lakeen Snelling, with her 2 attorneys by her side, sobbed in front of the judge as she pleaded guilty to major charges, including first-degree manslaughter. Prosecutors also put in what they believe her punishment should be. And we'll talk about that in just a moment. But we need to talk about the emotion that we saw in court today, because it is by far the most emotion that we have seen out of Lakeen Snelling since her arrest in August of last year, when we first started covering this story. And we've seen her in court multiple times. There are even moments where she smiled in court during previous hearings, but today was certainly different. And that's because she was admitting guilt in this case. Now, it takes a lot for an attorney to recommend to their client that they're going to have them plead guilty to what prosecutors are alleging. And we're going to
Before we go deeper into what the documents actually show, make sure you're subscribed to Trial Theory, Unsealed. Because we don't just cover the story, we follow the evidence. Think about the visual. A trash bag in a closet. Inside it, a newborn baby boy wrapped in a towel. Paper towels soaked with blood. A placenta sealed in a Ziploc bag. That is not a crime scene. That is a life erased by someone who had been flying through the air in a cheerleading competition 4 months earlier. April 2025, she was performing acrobatic stunts. August 2025, she was cleaning up evidence.
So let's go back to when this story began. It is 10:30 in the morning, August 27th, 2025, in Lexington, Kentucky. That's where the University of Kentucky is. That's where Lakeen Snelling went to college. She was there for 3 years, and then she withdrew after her arrest because of what prosecutors say happened. And law enforcement is called to off-campus housing in Lexington and to the home where Lakeen Snelling was living with her roommates. Now, Snelling had a lot going for her. She was a student at the University of Kentucky, but she was also a varsity athlete because she was a member of the University of Kentucky Wildcats stunt cheerleading team. And we're not just talking about a group that tries to get the crowd going on the sidelines of a football game. Stunt cheerleading is a lot of high-flying, acrobatic tricks, a lot of coordination. You take a look at this screen grab here from a video of the Wildcats competing. This is per Flow Cheer on YouTube. And this video was taken in April of 2025. And that means if the baby that Lakeen Snelling gave birth to was full term in August, that she was very much pregnant at the time of this competition. Now, when police get to Lakeen Snelling's home on that day in August, they find a baby in a trash bag in a closet. Police say the child was also wrapped in a towel. The baby boy was pronounced dead on scene. Now, the arrest citation reportedly says that when police spoke to Lakeen Snelling, she admitted to giving birth to the child. Then she allegedly said that she concealed the birth by cleaning evidence and putting all of the cleaning items inside a black trash bag along with the body of her newborn son, who was wrapped in a towel. Now, according to police, an autopsy showed that the baby was born alive and then died of asphyxia by undetermined means.
Let's move through the timeline. August 27th, 2025, 10:30 in the morning, Lexington, Kentucky. Police respond to off-campus housing near the University of Kentucky. Roommates had entered Lakeen Snelling's room. They had heard noises the night before. They found a blood-soaked towel. They found a black trash bag in the closet. Inside, the body of a newborn boy. The arrest citation tells us what Snelling allegedly told police. She gave birth around 4 in the morning. She fell asleep on top of the baby. When she woke, he was blue and purple. She wrapped him like a burrito. She laid next to him in what she called a moment of comfort. Then she left the house to go to class. She didn't go into the classroom. She sat in a car and ordered McDonald's through the app. That detail sticks. Not the horror of the act itself, but the bureaucratic normalcy that followed it.
She also said that she was awake for about a half hour, and then she fell asleep on top of the baby. When she woke up, she said the baby had turned blue and purple, and she reportedly said that she did not think the baby was alive. She then said she wrapped the baby like a burrito, laid next to it in what she called a moment of comfort, and then left. She also reportedly cleaned up the blood in her room with paper towels and put the placenta in a Ziploc bag. Now, even though, again, she just went through this major medical event, and she has her son who is dead, Snelling left the house to go to class. Then she said she didn't actually end up going into the classroom, but she sat in a car. And court documents say she ordered McDonald's through the McDonald's app.
At the hospital, according to court records, she told doctors something different from what she told police. She said the baby displayed a little bit of fetal movement. He made a whimper. She guessed the baby was alive. That admission mattered. Because if the child was born alive, and she deprived him of oxygen, the legal classification shifts. Not a stillbirth, a homicide. Here is the irony. The grand jury indicted her in March. First-degree manslaughter. The indictment language is cold and precise. She caused the death of the infant under circumstances which do not constitute murder, because she acted under the influence of extreme emotional disturbance. The law acknowledges she was emotionally distressed, but it also holds her accountable for the outcome. Both things can be true at the same time.
The indictment read, on the count of first-degree manslaughter, quote, she caused the death of the infant or with the intent to cause the death of the infant under circumstances which do not constitute murder because she acted under the influence of extreme emotional disturbance or through circumstances not otherwise constituting the offense of murder, end quote. WKYT television spoke with the Commonwealth attorney about how the grand jury landed on manslaughter as the charge against Snelling, and Kimberly Baird reportedly said the grand jury was given information about the 4 levels of homicide in Kentucky, and the grand jury decided first-degree manslaughter was the best fit based on the evidence in this case. So you can see there, prosecutors had a pretty strong case against Lakeen Snelling.
Digital evidence compounded the physical record. Police obtained a search warrant for her social media accounts. She had taken photos during labor, then she deleted them. That is not panic. That is presence of mind. That is the gap between emotional distress and conscious concealment.
And around the time Snelling reportedly said that she gave birth, one of her roommates texted a Snapchat group that they thought they heard something fall. And another roommate said that they thought they heard noises for roughly an hour. Now, after Snelling left for class, her roommates go into her room, and it appears that she never told them that she was pregnant, but they were suspicious. And when they entered the room, they allegedly found a blood-soaked towel and a plastic bag containing evidence of childbirth. And they also found that baby boy. And that's when they called the police. Now, Snelling eventually went to a hospital, and it is there she allegedly told doctors, according to court records, that the baby displayed, quote, a little bit of fetal movement, and he made a, quote, whimper. And she, quote, guessed the baby was alive. Now, those statements, you can tell, very important from a legal perspective as this case goes forward, but it's also a bit different from what she allegedly told police, according to court documents. Now, on top of the physical evidence, there appears to have been a good amount of digital evidence against Snelling. Police say that they have images of Snelling that she allegedly took during labor that she then deleted. Police said in a request for a search warrant for her social media accounts that they could, quote, contain current or deleted information that relates to Miss Snelling's pregnancy to the birth of the full-term baby and ultimately its potential demise, end quote. A grand jury heard Snelling's case in January, and the indictment came down in March.
Then we arrive at the plea hearing. The judge asked if she was satisfied with her attorney. Yes, ma'am. Under the influence of drugs or medication? No, ma'am. The answers were mechanical. Then the judge turned to the facts. Tell me what you did. She sobbed. She spoke. I was under a lot of emotional distress, and my baby came unexpectedly. The judge pushed. When you say instead of helping him, you did what? The answer came. I ended his life. How did you end his life? I deprived him of oxygen. That is not a confession extracted through coercion. That is a methodical allocation. A defendant placing each element of the crime on the record, one word at a time. She deprived him of oxygen.
And instead of helping him, I ended his life. And afterwards, I cleaned up and didn't tell anyone.
Okay. So tell me, when you say instead of helping him, you did what?
I ended his life.
How did you end his life, ma'am?
I deprived him of oxygen.
Okay. All right. And did you tell me about this tampering with physical evidence? What did you do with the evidence that could have been collected?
I put the towels in a plastic bag.
Okay. And what about this concealing the birth?
I didn't tell anyone after.
Okay.
That is Snelling, in her own words, making a shocking admission in court. And Snelling agrees to everything that has been alleged against her for more than a year. The judge asked prosecutors what they want for a punishment, and this is what they said.
What is the recommendation from the Commonwealth as it relates to Ms. Snelling?
She put the towels in a plastic bag. She didn't tell anyone after. Each admission maps directly to a charge.
Count 2, abuse of a corpse, 1 year as charged. Count 3, tampering with physical evidence, 1 year as charged. And count 4, concealing the birth of an infant, 12 months as charged.
So just so we're on the same page here, we're talking potentially 10 years in prison for manslaughter. And then you have 1 year apiece for the remaining 4 counts. You have abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. Lakeen Snelling will be sentenced on October 16th. Join us now to talk more about this and what could happen next. Criminal defense attorney Sky Lazaro, always great to have you here on Law and Crime. It's a terrible story, and it looks like now Lakeen Snelling will be headed to prison to some extent. Looking up at Kentucky law, mandatory between 10 and 20 years. Prosecutors asked for 10, which would be the minimum of the mandatory.
The Commonwealth recommended 10 years for manslaughter, 1 year for abuse of a corpse, 1 year for tampering with physical evidence, 12 months for concealing the birth. 10 years is the mandatory minimum in Kentucky. So here is the question that reframes this entire story as a legal thriller. What happens on October 16th when the judge decides whether 10 years is enough or whether the evidence demands more?
Yeah, first of all, this is a really, really tragic case. And we heard from Lakeen in her own words today when she had to tell the judge what exactly she did to satisfy the elements of the crime, that the baby was born alive and that she restricted his breathing or essentially asphyxiated him, and that was the cause of death. What we're going to see at sentencing is she pled essentially to everything in this case. She pled to every charge, the manslaughter being the lead charge and carrying a possible prison sentence of 10 to 20 years. Sounds like, my guess is the prosecution's asking for 10 because she took responsibility and pled to everything. But ultimately, this is going to be up to the judge. She's going to go do a pre-sentence report. They're going to come back for sentencing. There's a lot that's probably going to go into this sentencing. People can write letters on her behalf. Victims can have the right to be heard or a representative. I don't know if the father of the baby's family is involved in any way, but they would have a right to be heard possibly at sentencing. So ultimately this will lie with the judge how much time she's going to do.
What did you make of just how this went down today? Because this was supposed to be, or at least, who knows what the prosecutors knew ahead of time. They seemed prepared, but as far as the docket, this was going to be a status hearing, and then it's, changing her plea from not guilty to guilty, and then we hear her in her own words for the first time. As someone who's a criminal defense attorney, what's the coordination that goes into what we saw play out in the courtroom today?
Yeah, and these are interesting because the public doesn't get, much of a heads up on these because there'll
Right.
be a status hearing. But these conversations, she has very good defense lawyers. These conversations, they were clearly well known to the judge as well today when we watched the hearing. But these conversations have probably been going on for quite some time.
Consider the moral refrain. She deprived him of oxygen. That phrase is the case. It is the act. It is the consequence. The law does not care that she was a cheerleader. The law does not care that she was under emotional distress. The law cares that she made a choice in a dark room at 4 in the morning, and then made another choice to conceal it. She deprived him of oxygen. That is why this story is not about a young woman's tragedy, but about a newborn's death.
Uh, she was very sad. I think this has become very real for her. It's these cases are interesting. She's young, first of all. She's 22 years old now. This case has been going on for a little bit. She's outlined that she was under, this emotional distress. It's probably not enough to be helpful. And I say that in terms of having a mental health diagnosis that would be able to lower this down to a lower level crime based on a diminished capacity. But she was broke down and was sad. And these cases are interesting. And watching her today, I've seen people go through this. It gets real fast when they have to get up there and say it in court. It's one thing, something bad happens or they do something bad, and a lot of people panic and do things to cover it up. I don't think that that's uncommon, and we see that a lot in the criminal world. But today it seemed very real to her that she was understanding at least what she did, and she was pretty upset about it. I mean, she broke down in tears. I don't think that those were forced tears. Now, whether she's sad about what happened or she's sad about going to prison.
Now the call to research. The indictment is public record. Docket number 26, CR 209. You can find it through the Fayette County Circuit Court Clerk's office. Read the language of the manslaughter charge. Read the elements the Commonwealth had to prove. Then ask yourself one question in the comments. Did the plea deal serve justice, or did it simply serve efficiency?
How do you, because I mean, for her attorneys to get to the point where they say, we're not going to take this to trial. This is probably the best bet at this point. And it did seem like there was some pretty strong evidence against her in this case. Like, how do you deliver that news to your client where there's this realization of like, especially at 22 years old, you think of what life would be like at 32. I mean, 32, I'm far older than it now. Like I thought 32 was old when I was 22 years old, right? And like the idea that she's going to go to prison potentially for that, if not longer with the other charges, like what are those conversations like between an attorney and a client?
They're hard. And that's why it takes a lot of trust. And it takes building a really good relationship with your client in cases like this. These cases they're tragic, they're heartbreaking, they're difficult from every level. You don't want to go to trial on it because there could be stuff out there that if the judge hears, she's going to get maxed out. There's cases where you just have to take responsibility, and everybody starts from, especially if they've never been in trouble. I don't want a felony and I don't want to go to jail. I mean, that's great. Nobody does, right? So to work with somebody to get them to a place of accepting responsibility and accepting the fact that they are going.
If you found this breakdown useful, like this video, share it, and subscribe to Trial Theory, Unsealed. Turn on notifications so you don't miss the sentencing hearing analysis. The next document drop is always the one that changes everything.